In 1888, the Supreme Court declared the Federal Civil Rights Act, which banned racial discrimination in various private businesses, to be unconstitutional. In doing so, they established what came to be known as the State Action Doctrine. The State Action Doctrine meant that the 14th Amendment and the Equal Protection Clause only ban public discrimination, not private discrimination. Therefore, the federal government had no power to regulate discrimination by private businesses and private individuals. For decades afterward, businesses in many states across the country openly discriminated on the basis of race. After World War II, things began to change. Progressive members of Congress began to push for new civil rights legislation. This was bitterly opposed, especially by white Southern Democrats, who used every trick in the book to block it for years. But their opposition finally failed when Congress passed a major new piece of legislation, the Civil Rights Act of 1964. The Civil Rights Act of 1964 was very similar to the Civil Rights Act of 1875, but it was even more expansive. It prohibited racial discrimination in education, employment, banking, housing, and all businesses with more than 15 employees that are involved in interstate commerce. Businesses were prohibited from discriminating against both the customers they served and the employees that they hired. But opponents argued that the State Action Doctrine meant that the new law was unconstitutional. One of those was the Heart of Atlanta Motel, a white-owned business that did not want to serve black guests. So they filed a lawsuit, which was decided by the Supreme Court later that year. In Heart of Atlanta Motel v. U.S., the Supreme Court upheld the constitutionality of the Civil Rights Act. In doing so, it did not overturn the State Action Doctrine. The 14th Amendment still does not give the federal government the power to combat racial discrimination. So why did the court find the law to be constitutional? The court said that although Congress doesn't have the power to ban racial discrimination under the 14th Amendment, Article 1 Section 8 of the Constitution does give Congress the power to regulate interstate commerce. And because the Civil Rights Act regulates interstate commerce, it is constitutional. But opponents objected. They argued that Congress's real motivation was not to regulate commerce, but rather to regulate morality, and that the economic argument was just an excuse. But that didn't matter to the Supreme Court. It said that Congress was legislating against moral wrongs in many of these areas rendered its enactments no less valid. The court said that African Americans and other racial minorities might decide not to travel if they were unsure of whether they could obtain a meal to eat, or a bed to sleep in while traveling. This would have a clear effect on interstate commerce. Congress was also dealing with what it considered a moral problem. But that fact does not detract from the overwhelming evidence of the disruptive effect that racial discrimination has had on commercial intercourse. This was a major decision. Businesses that had formerly refused to serve black customers or hire black employees were now required to do so, and could be sued if they discriminated. But many businesses didn't want to comply, and they were looking for ways to avoid the ruling. They emphasized the fact that the Constitution only gives Congress the power to regulate interstate commerce. In other words, it can only regulate commerce between states. Congress has no power to regulate commerce that occurs entirely within a state, which is called intrastate commerce. Therefore, some businesses that wanted to continue discriminating attempted to argue that they were not a part of interstate commerce. For example, the Supreme Court decided a case called Daniel v. Paul. Daniel v. Paul involved a small entertainment complex called the Lake Nixon Club. It offered swimming, boating, dancing, and a snack bar. It was located about 12 miles from Little Rock, Arkansas, and it didn't want to serve black patrons. It filed a lawsuit claiming that it did not need to comply because it was not involved in interstate commerce. It claimed that it was a local business that didn't advertise, and it attracted only local customers. The Supreme Court disagreed. It noted that the Lake Nixon Club had several connections with interstate commerce. Much of the food that it purchased came from out of state. It also had a jukebox with records and paddle boats, all of which were manufactured in other states. These connections were enough to bring it within the scope of the Civil Rights Act. When the court upheld the Civil Rights Act of 1964, It completed the job of repairing the damage that it had done in Plessy v. Ferguson and the civil rights cases decades earlier. Regarding public discrimination, Brown v. Board of Education overturned Plessy and its separate but equal doctrine. And while the Heart of Atlanta Motel case didn't overturn the state action doctrine regarding private discrimination, it had essentially the same effect, because the court now said the federal government did indeed have the power to combat private racial discrimination.